the National Labor Relations Board's acting general counsel rescinded a key memorandum that had classified college athletes as employees under the National Labor Relations Act. The decision reverses a stance in 2021, which argued that college athletes provide services to their schools in exchange for compensation and should have the right to bargain collectively. This move comes amid ongoing debates over whether athletes should be considered employees. The NCAA and universities have long fought to maintain the traditional student-athlete model, and efforts to pass federal legislation preventing athlete employment status have stalled. A bill advanced in Congress last year, but failed to progress further. The timing of the decision aligns with other policy shifts. Just days prior, the Department of Education rescinded guidance that subjected athlete compensation under name, image, and likeness, NIL, agreements to Title IX gender equity regulations. These changes reflect a broader shift in approach under the new administration. The rescinded memo contributed to two significant labor efforts. Dartmouth's men's basketball team pursued unionization while the NLRB's Los Angeles office filed a complaint against the NCAA, the Pac-12, and USC for misclassifying athletes as student-athletes instead of employees. Both efforts were abandoned, mainly because of concerns that a ruling under the new NLRB composition could set a lasting precedent unfavorable to athlete labor rights. The complaint sought to redefine the employer-employee relationship in college sports. It argued that private organizations, the NCAA, and significant conferences functioned as employers of athletes, potentially opening the door for unionization of public universities. By rescinding the memorandum, the NLRB has removed a key legal argument supporting that claim. The decision marks a setback for those pushing for athlete labor rights, reinforcing the NCAA's position and limiting immediate unionization efforts. However, the debate over athlete compensation and employment status remains unresolved, and future legal and legislative battles will likely shape the college sports landscape.